Hi, good afternoon. Today is January 18th, 2026, and it is 4:54 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I am recording this video from my home located at 2302 Britton Ridge Drive, Katy, Texas, 77494. And this house is located 250, 300 feet away from the home of Robert Mueller, who was the director of the FBI for several years, for many years. And that is relevant to this conversation. So this is demo D98. It's going to be a short session. I just want to record a few things that I got over the past few days from the informant. The guy that is a buddy of Diosdado Cabello, and he passes me information because he wants to, depose Diosdado, I imagine, right? So there's been a few developments, right? That I want to record, and I want to, more than record them, I want to timestamp that I said these things and that he told me these things, right? Before, if they happen, that would just prove that all this is designed and that the informant is accurate. So I'm gonna say these things. So this is going to be a very unusual because I have not prepared a list of talking points, and the reason why I did that is because I didn't want to give them any advantages, in terms of what I'm going to say, because then they could go and do something right before I say it. So I may have to think about what I'm going to say because I don't have a list, right, of things that I want to say. So I have to remember. I have to go by memory of the things that have happened. Okay. So let's start by what they're planning to do, like the things that I don't know if I would call them threats, right? Because I don't know if they would actually do them. Given that they have the authorities breathing down their neck. So I don't know if they would actually take those steps, right? But this is what they're planning to do, right? What they have planned to do, but they haven't triggered it yet. But they may trigger it, right, in the following week, or I don't know. So they have different fronts of attack, right? So this is from what I gathered from the informant. And I want to tell you before I begin, I want to show you this. I have a series of letters here that come from this law firm. I'm going to show you. This is the Robert Markel Weinberg Butler Haley PC, right? This law firm in Houston. And what I want to show you is two things, right? One is that I haven't opened this, right? I don't know what the letter says. And some of these letters seem to be old letters from when they had my mail stop at USPS, but the mailman brought them, right? So I imagine because they want to say that I did receive them, right? They have a witness, the mailman, that's going to say that he gave me the letters, right? But I want to show you that I have not opened this, right? So I don't know what it contains, but I mean, I know because the informant told me, right? But I have not opened them, so I haven't read the letters. But I know what this is going because the informant already told me. And the other one is this one, right? And you can see that it's closed and it's sealed, and I have not opened, right? And interesting, and this is very interesting. So if you look at the recipient, I'm going to show you. I'm going to try to show it to you. So it's addressed to my company, so the company that publishes the books, that mentions them, I mean, the attorney, right? But it says below, it says registered agent Rinaldo Aguiar. So it has my name, right? So, but that's something that they put because when so the corporation owns the house. And I was careful that when I fill all the forms to register with the HOA, the home, I did it on the name of the corporation. I never put my name or my phone number of any of those forms. So they have no way to know, really, in reality, that the registered agent, I mean, in fact, I am not the registered agent of the company. I can tell you that. So, but they're putting that to create legal liability on me personally, right? So this is a legal move to tie me personally to the things that they're going to do with that judge, right? That they're working with. That the informant already told me, right? But I'm showing you the letters to show you that I have not opened them. So I have no way to know what it says, right? Unless what the informant, except for what the informant told me. And if this is the case, it means that the informant is correct, right? That he got this information from them. So yes, so basically what they're working on is how to get me in prison quickly, right? So they're working on 3 different avenues, right? Whatever works better, or first, I don't know, right? I imagine they're gonna pick one of the 3, right? So the first one, the obvious one, is with Josh Telfer, right? On that hearing on the 22nd, where and that's another communication that I have not opened. And I mean, I cannot show you the envelope because this was electronic, but if this gets to the FBI, they can check my access logs on my email, and you will see that I have not opened my email in 2 days. And I've done this in purpose because I haven't had a chance to record this demo, and I don't want to see the filing from Pickett before I record this demo, because I want to say what the informant told me. Right? So you can see that he's accurate, right? So if this ever gets to that point, I implore authorities check my email access logs, and you will see that before I recorded this demo, I did not see that letter, and I could not see it in the docket because they marked the document as private. In fact, let me show you that right here, so you see what I mean, right? So. So you see, Troy Pickett filed on, and this is odd because this appeared in the docket yesterday, Friday, but it says that it was filed on the 16th, which is not true because I have screenshots, I have copies of the docket from the 16th and the 17th, and this wasn't in the docket. So it was added after, but it doesn't matter, right? So he responded to my motion to recuse, which is kind of odd because the motion to recuse is directed to the judge, not to Pickett or his client. So and it's an automatic stay that gets triggered by that. It's not, he has no saying, and he has no way to respond to that. It's a rule, right? It's a procedural rule. If there's a motion to recuse, that procedure gets triggered. The judge has to either recuse himself or route this to another judge for a decision, right? But Pickett felt like he had a need to respond. Anyhow, if you click on that and you click on the actual document, you can download it. You see, it's marked as private, so nobody can see it. I should have a copy of this in my email if they serve it to me, but I have not checked my email precisely because of this reason, right? What I said. So this is the second avenue, right? And I'm going to describe in detail what the informant told me about these different avenues, right? And the third avenue is, again, an accusation for sexual battery, right? Or something like that, rape or something horrible like that, right? Involving my former partner. And the informant told me already the mechanism of that. So let's start by that, because that seems like the most dangerous, right? So last night when I went out, after so what happened yesterday was my former partner sent me a message at the end of the morning saying, hey, are we going to see each other at 4 p.m. so you can see the kid, right? Which was, to be honest, strange, because in the last, I don't know, 7 or 8 months, if I don't ask to see the child, she doesn't offer it, right? Like it has never happened that she proactively invites me to see the child, right? Because, the child is the weapon, right? So, actually, let me stop sharing this. Right, so she invited me, right? And I said, well, yes, of course, I would like to see, to see the child and to see you as well. So I went to the other home and we met there, right? And here I want to, be respectful of be respectful of her, right? So I don't want um, to give more details, but um, the the rules, right? And the informant told me how it works. It's so she was carrying a water bottle that is purple. It's metallic and purple, and he told me that that water bottle is bugged and it has a microphone. So they're recording everything that I say or that she says, right? While we're at home, she made a few comments that I'm going to describe the comments, okay? But and I'm going to describe it in the context that she said those comments. So one of the comments was that she said that she was hurt, and she was talking about the divorce proceedings, right, and the litigation and all those things. And she felt like she said that she was hurt and that she was in pain, right? She said those words, and of course, she's telling me that in the context of the litigation, of course. And when I hear those words, my reaction was to say, but don't worry, everything is going to be okay. Nothing happened. Things like that. Like, you are, you're not harmed by the situation to be in this, like crying and stuff, right? I mean, if anybody should be feeling pain, should be me, right? That has been deprived from my parental rights from 10 months. Like, she has had the child for 10 months, full time, right? That's what I tried to say. But anyhow, I didn't make much of it, right? Then some time passes, and she made another comment in another context. Okay, she said, that she was in her days, basically, right, and that she was bleeding, and that she needed to go to the bathroom. And she excused herself, and she went to the bathroom. I didn't make much of it, right? I mean, it seemed like something that happens, right? But she said those words, like that she was in pain and that she had to go to the bathroom, and that she was bleeding, right? But the informant told me, and then we left the house. At the end of the evening, she was in a better mood, and we said goodbye. I said goodbye to the kid. Everything was normal, right? And then I go out and I collect the messages, right? When I get home and I decrypt them, I'm surprised, right? The informant is telling me that all that wasn't rules. That those segments of conversation, because think about it, right? If you take them out of context, I mean, look, if you really hear what she said, right? In one, she said that she was hurt and that she was in pain, right? She was talking about emotional pain, but that is not clear. I mean, if you only listen to the audio, if you cut that segment of audio and you just listen to that, what you're hearing is a woman that is in pain and that is hurt, right? I mean, it could be interpreted as she's physically hurt, right? That's the rules. And then in the other message, she says that she's bleeding and that she has to go to the bathroom, right? If you put the two things together, that sounds like a woman that was raped. So they're going to take that to a judge, and they're going to get, and he also told me, and this is true, like he told me that I didn't remember when he told me, I remember it. She made a comment that something along the lines that you are recording me. So she said, after she said she was hurt, she said, you are recording me, and I don't want you to record me, right? And the informant told me that that piece of audio was important for them because they're going to try to use that as a pretext to get my computer seized, which is what they want. They want to destroy the evidence, right? The evidence, all the recordings that I have, and all the damning evidence that I have, they want to destroy it. Get the passwords, get the credentials, everything, right? So one way to do that is by them going to the police and making this false narrative and say that I am illegally recording women in the bathroom, things like that, right? So that's one avenue of attack that they are preparing for, right? Now, I have to tell you, I think it's a pretty crazy endeavor to take on because they already have the FBI breathing down their neck. And I know that. And they know that. And they know that I know, right? Here I'm going to say something that the informant told me like 7 days ago. I haven't said it because I don't want to, interfere with the investigation, right? I know authorities are investigating this thing and I don't want to get in the way. right? They have their process, and they know how to do this thing, right? Like, they know the timing in which they notify people that they're being investigated. Like, they decide those things. I'm nobody to get in the way, right? But here I have to say it because, I'm to deter them, right, from taking this step. So the informant told me, and I'm saying this because I know that they apply information asymmetry. And I know that not everybody in the network, is possible that the judges don't know, like, not the judges, like, not all the judges know this that I'm going to say, right? But this is true. Believe me when I say this. The DOJ is already proactively contacting people and interviewing them. Judiciary actors. Now, I'm not going to tell you which ones, but this is something that has already happened, and since more than a week ago. So, at this point, right? I guess you will have to do a team meeting among all of you. I'm talking to the network, right? You have to do a team meeting among all of you and raise your hands who's been interviewed, something like that, right? It's the only way to know, because I'm guessing that if the people that get interviewed, maybe they get offered a deal, right? But we're going to give you a deal if you cooperate and you don't say anything about what we're doing, right? So I don't know. It seems to me like a situation that you cannot control, because you don't know within your own network which judges have already flipped. Like, how you're going to determine that? Unless you have somebody in the DOJ that is working on this project, right? Which I don't think is the case, because if it was the case, it wouldn't have gotten to this point. But anyhow, I think it's a pretty crazy endeavor to take on, because if you have the DOJ breathing down your neck and watching you and already flipping judges, if you take that step, they're going to get you red-handed. And they're going to get all of you. And remember, it's a RICO enterprise. You share the crime. Like, the worst crimes get shared across all the team, right? So be careful. Because, I don't know. I've seen this in the movies, right? I don't know if this is Hollywood fabrication, but according to the movies, the FBI does this thing where they actually help the criminals commit the crimes. I'm not saying that they participate in the commission of the crime, but like, they make them believe that they're committing the crime, right? And right, at the last moment, they say, "Hey, surprise, we're the FBI," right? So be careful with that, because that could be what's happening. So, before you go and make those grave accusations that are unfounded and untrue, because I haven't raped anybody, before you take that step, think about that twice. Well, I'm going to tell you that other thing later. Yeah, so that's the attack number one, right? So that is, again, using my former partner again. So kidnapping the child wasn't enough. Now they're going to use her to do this, right? So that's vector number one. Vector number two is Judge Telfair on the hearing on the 22nd. The idea there is that Troy Pickett is going to stand up, right, like a paladin of justice, and he's going to say, this is a technique to delay the trial, right, and to keep the child in danger, and something like that, like he's the good guy, right? And the Judge Telfair is going to deny the motion to recuse. And he's going to go ahead with the meeting, with the hearing, and he's going to find me in contempt and put me in jail. Of course, this would be another procedural violation, another violation of my civil rights, because I already filed a third verified motion to recuse that got into the docket, and he responded to it. So I have the right for this motion to recuse to be assessed by the proper judge that is unfair and impartial, and that cannot be Judge Brown. And I'm going to tell you in a minute why that cannot be Judge Brown. But I also put it in writing in my motion. By the way, my motion to recuse, I marked it as public when I submitted it and filed it, but the clerk, again, marked it as private, right, to keep everybody in the dark, so nobody can download this motion, right? Which is it, right, because now I put it in a book. But anyhow, so that's the plan, right? The argument, and this is the reason why I haven't checked my email and I have not downloaded the document, because this is what the informant told me. He told me the argument. Sorry. This timer thing is annoying. So he actually told me the argument that Pickett made in that response that I haven't read, right? The argument is something, I mean, the informant is not a lawyer, right? So this might be a bit distorted, but more or less this is what I got. That the argument is that I created the criminal complaint with the DOJ as a way to create an excuse to say that the judge is not partial, right? So implying that I fabricated the criminal complaint that I'm a crazy person and I'm going to file a false complaint with the DOJ, which could land me in jail if I do that, right? If I know that it's false and I file a complaint of that severity and nature with the federal government, right? I mean, that's crazy. To just delay a divorce proceeding. But anyhow, that's what he's going to argue, right? That the criminal complaint is fabrication. Like, they are not criminals, they are not committing crimes. It's just me fabricating that with the DOJ to delay the divorce, right? And based on that, Judge Telfair is going to rule I mean, he's going to abuse his discretion and he's going to deny the motion to recuse, which he can't. I mean, he can't do that by the procedural rules only give him two paths. He either recuses himself or he forwards the motion to another judge. He doesn't have any other option, right? That's what the rule of procedure says. But of course, I understand that these people don't, they don't do what the procedure says. Like, they do whatever they want, right? But that's precisely why they're in this situation where now there's a book of 600 pages of evidence on its way to the DOJ. Keep going, because I have 200 more pages of space to fill on this book. I can put up to 800 pages. And right now it's 597. I still have a space. So that's the plan with Judge Telfair. But this is a mistake. And again, I haven't opened the document, I haven't downloaded it, I haven't run the legal pipeline. But even without running the pipeline, if this is what they did, this is a horrible mistake. And I can see that just being a human, like not even using the computers, the servers. I can see how this is a mistake. Because if Pickett argues, I don't want to get ahead of myself. I have to run the legal vaccine, right, to be sure. But my thinking would be, right, just looking at this situation, if Pickett argues that, it's a mistake because he would be opening the door for me to go and say, no, I filed complaints against Judge Telfair since June. He's in the cover on the book that I published on May, before even the void order going to the record. I put Judge Telfair in the cover of my book, which is in Amazon and has the publication date. So that isn't true. So he's going to open the door for me to include the entire book and the IRS reports in which I reported Judge Telfair to the IRS. And all of them know that, right? And I reported Pickett to the IRS months ago, right? Before even the motion for sanctions and the void order, before even all of that, I already had reported both of them and Judge Brown as well to the IRS. So of course they cannot be impartial. How can you be impartial to make a judgment that affects a litigant that reported you to the IRS? So he's going to open the door. If that's what he did, he opened the door for me to put that into the docket. Right? Go figure. So, I'm going to tell you this. This is the thing, right? This is why I want to keep my talking points, because to keep the conversation organized, right? But anyhow, I'm going to keep going in order, right? So that's the second vector of attack. Judge Telfair on the 22nd with, the response that supposedly is going to give the judge the power, the superpower to deny the motion to recuse, right? Himself. I don't know, it just sounded like the thing with the secretary, right? I'm going to tell you about that in a minute. Okay, and the third avenue for imprisoning me quickly. Well, I don't know if this would. I mean, they can do anything they want, right? Because they control the judges. But so this is what happened, right? So is with the HOA, Phil Denning, and the Robert Markel, Weinberg, Butler, Haley, PC law firm in Houston, right? So Phil Denning has been harassing me with that, with those frivolous lawsuits for a year, right? They had my son kidnapped, and at the same time, they marked my house as vacant, so I could not receive any mail. So I never received any documents from the court or judgments, anything. I didn't receive anything. But lately, they've been sending me a lot of things, right? And these are these 3 letters that I showed you that I haven't opened because I want to record what the informant told me. So what the informant told me is that they're going to ask a judge to put me in jail for contempt of court, which would be, illegal and a stretch by any means, any metric that you look at it. First of all, because this is a company, the house is owned by a company. The judge would have to put in jail the company, not me, right? And they're making this leap, and that's why they're putting my name as registered agent in the envelope, right? To then say that they have legal ground to ask for imprisonment of me personally. They are trying to tie me to the company, right? By force. But even, right? I think about it as a reasonable person, right? Would it be reasonable to put a person in jail for a dispute with an HOA? I haven't opened the letter, so I don't know what was the default judgment that they entered. But looking at the history of the conflict, I imagine it's not a high amount because at that point I have already reported them to the IRS, right? So if they try to put a punitive amount, right, like $100,000 in fines or something like that, it would be clear to the DOJ, for example, that they are retaliating against a whistleblower, right, by imposing these unreasonable fees. So I imagine it's something that looks reasonable, right? That's $3,000, $5,000, whatever, right? In the demand letter, which was the only thing I saw because they sent a server to harass me with that letter, and I'm talking about maybe 9 months ago. The demand, the monetary demand was $3,000, right? So all this was for $3,000, right? So would it be reasonable to put a person in prison for $3,000? I mean, when the attorneys, if you look at the hourly rate of that law firm, is in the hundreds of dollars per hour, almost $1,000 per hour. It just doesn't add up, right? That such an expensive law firm, of course, this is just a sham procedure, right? It's just harassment. But if you look at it objectively, right, it's obvious that this is harassment because such a high price legal firm being used for such a low level on expensive damages for a civil action over a dispute over a no trespassing sign. And let me show you the sign. So the dispute, the reason for the dispute is because I put this sign in my loan, right? So because of this, they are asking for $3,000 in damages. And now they want to put me in prison because I put this, right? Because I'm asserting my right to property. It's harassment, right? But from their perspective, it's just one possible avenue to get me in prison for contempt, right? So that's what they're doing. But again, right, I think it's a stretch by any means you look at it because first of all, it's a company, right? They have to sue the company. They could put a lien on the house, like there's a series of less severe actions that they could take, right? If they feel like their rights have been compromised by my inaction because they mark my house as vacant, right? But besides that, they could justify that I did not pay the $3,000, and if they feel strongly about that, they could put a lien on the house, right? But seeking imprisonment of a person that is, it's not even it's a company, right? And they're going to imprison me, right? That's why they're putting my name on the envelope, right? To make that connection between me and the company, which they don't have really, right? Because in none of the forms of the HOA, I put my name personally, not even my phone number. In fact, there was and I'm telling you this in case the FBI is interested in looking into that. There was an instance in which Phil Denning left me a voicemail in my 650-479-6157 phone number. And that is an anomaly because I did not put that phone number in any of the forms of the HOA. There's no way that Phil Denning could have had that phone number. So when you interview Phil Denning, which I imagine will happen at some point, please ask him, how did he got my phone number, my Google Voice phone number? Because I did not give that phone number to anybody in the HOA. But he had it, right? Somehow. Well, he had it because the Venezuelan intelligence gave it to him. Right? But anyhow, so that this is the third avenue. So also in my exchange with Informant, he told me, so describing demo D96 how I use demonstrators, right, to tune the algorithms. But I also, and I didn't say this in that demo for strategic reasons, but I obviously also use demonstrators in other areas, right? For example, in what actions to take. Like, for example, I know, right, because I filed hundreds of, well, not hundreds, but say probably at this point, yeah, like 60 or 70 IRS forms 211 over the last 15 months with the IRS. None of them has been taken action on, right? Because they're blocking them with the IRS. So of course I understand, and they let me file them, right? Like they don't block them. I mean, they don't stop the mail. Like they some of them reach the IRS, right? And then they block them there, right? But I understand. I guess what I'm trying to say is that when I file those, they don't try to harm me physically, right? They don't take extreme action, right? Or they don't try to put me in prison, for example, right? That tells me that they have the situation on the IRS under control, obviously, right? It's not something that they fear. But when I started filing things with the DOJ, I started getting feedback, and I described this in demo D96, right? With the books. I didn't say the DOJ, but I see the same thing with the DOJ. When I file things with the DOJ, then they try to rush to, harass me with the courts or put me in prison with all these things, or, like my former partner sends me a text message to ask him if I want to see the child, and then she takes that bottle that is bugged into the house, right? And then she starts making all these comments that I'm recording her and that she's bleeding, and that, all these things start happening, right? When I file things with the DOJ. So of course, I understand that the thing that hurts is the DOJ, right? And here, like I had a realization, like that I'm, how do I say this? I try not to beat myself down. I mean, I try not to be hard on myself for not having seen this before, right? But I see this now, and I see, yes, it makes sense, of course, right? I kind of feel bad because I did not see it in so long, right? In I don't know, over a year, right? So I mean, I started like filing complaints with Ken Paxton's office, right, or with the IRS, right? Thinking that would help me, right? But seeing the reaction now that I'm filing things with the DOJ, I understand, right? And I understand that if I was a lawyer, if my profession was in the legal profession, I would have seen this on day one, right? On day one, I would have thought what you have to do is contact the DOJ, right? I mean, day one of the legal harassment, right? When they started harassing me with the legal firms. But that thought never crossed my mind, right? Because I'm approaching this problem as an engineer. And at the end, I got to there, right? To that point, right? To that conclusion. But I got to that conclusion by experimentation, by A/B testing, right? By, aiming at different places and seeing where is that they react, right? But through all this process, now I have it narrowed down, and I know that the way to destroy them is the DOJ. That's clear to me. And thinking, putting that in perspective, thinking about that retrospectively, I understand, right? Because I mean, the DOJ is an agency, is a department that has prosecuted presidents, right? I mean, they haven't been successful, or I don't know. You can argue about the degree of success that they had in those, and I understand why, right? Looking at the index and the database that Josaro Cabello leaked to me, I understand why the success was limited, right? But I understand. I mean, this is an agency that is going to get to the point to prosecute a president, right, or a former president. So of course they're going to prosecute them, right? But I did not understand that, right? Because my mindset is the mindset of an engineer. I'm not a lawyer, right? But like one learns and evolves, right? So now that we know which is the path, which is the DOJ, right? I've been filing things with the DOJ systematically. And, I'm going to give them a little bit of information here to the network, right? You see why I kept filing things with the IRS, right? Knowing that you would block me. I was building, let's call them devices, right, that I could deploy with the DOJ later, right? And now I have all these devices, and I have just sent like 3 supplements. I can't send more. Like if you keep going, I will keep sending more. And like there's all those Chinese institutions that are in finances, the steel companies. Like there's no end to this, right? So if you keep going, I'm gonna keep sending supplements. And as I said, I have 200 pages of space, and if I run out of space, I will make volume 2. Right? So think about it. And like I kind of hinted at this the other day when I made a joke on the YouTube channel, right? I said something like it was a text comment. I said something to the effect that the pipeline is developing a dark sense of humor. And what I meant, you know what I meant, right? The Supreme Court of Texas denied summarily the petition for writ of mandamus, right? The moment I filed that criminal complaint with the DOJ. But now there is a motion to recuse, and this was designed by the pipeline. I didn't come up with this strategy myself, right? I came up with the software, I came up with the strategy, but I didn't come up with the strategy. Now, you see the path, it's clear, right? Judge Telfair obviously has a conflict of interest because I reported him to the IRS, I reported him to the DOJ, and there is a book, and his photo is in the book, in the cover, and that book was published in June 2025, 7 months ago. How can he say that he doesn't have a conflict of interest? Let me show you the book, if you don't believe me. So if you go to Amazon, look, this book was published on September 28th. Imagine that. So before the void order was even created, because that was created on October 15 after the court had lost jurisdiction. Right. So this book from September 28th, right? If you look at the cover, Judge Telfair is somewhere around here. Where is him? Here he is. So he's next to Greg Abbott and William Kyle Adams and David. And this is a long story, and this is explained in the book that I sent to the IRS. This cover is not created by me. This is created by an algorithm based on the data in the database of Diosdado Cabello, and the size of the image depends on the prominence of the agent. And the distance to Diosdado Cabello is this one that you see here. There's so many faces that it's hard to see, but this one that you can only see the eye here, the bigger picture, the biggest picture is Diosdado Cabello. So the distance to Diosdado Cabello and the size of the image are 2 signals that encode the prominence and the liability. And Judge Telfair is here with David Sperwin, which was the mediator that the other judge that worked with Telfair, his name is Richard Bell, who's the one that signed the mysterious TRO that is missing from the docket, ordered me to go through, right? And that judge, he was a former judge in the same court as these judges, right? I'm talking about David Sperwin. And David Sperwin was appointed by Greg Abbott. That's why they're clustered together closely in that cover. And William Kyle Adams is closer to Wilmer Ruperi. Wilmer Ruperi is this one that you see here that is huge, the huge picture, right? Because of the huge prominence score that he has in the database, and he's closer to Diosdado Cabello for obvious reasons, right? But I don't want to get too much into the technical details on how the cover is generated, but you can see that Judge Telfair is there, right? So, and this book was created on September 28th, 2025. So October, November, December, January, 4 months ago, right? How can Pickett say that I'm creating these claims as an excuse or to create to fabricate the conflict of interest, right? The conflict of interest has been there since day one, right? I mean, since they joined the network, right, and decided to work on this project. And Judge Brown is also here in the same cover, right? She is here, right above Travis Kalanick and Peter Thiel and Piero Midyar. So that gives you an idea of the prominence of Judge Brown. Judge Brown would be the administrative judge that would naturally would have to review this third motion to recuse. But how can she be impartial judging this third motion to recuse when she is in the book and I reported her to the IRS, right, and to the DOJ, right, because she denied two of the motions to recuse that enabled the court to abuse and deprive me from my civil rights and rights to the process in this way. So she cannot make that recusal, and I put this in writing in my motion to recuse, right? I'm asking that this is not reviewed by Judge Brown and that she doesn't appoint a successor because she has a conflict of interest. She's going to appoint somebody that, plays for her team, right? So who is this going to go to? This has to go back to the Supreme Court of Texas, right? I mean, the motion to recuse. So what I'm saying is that this motion to recuse is going to land back in the same desk of the judges that dismissed summarily my petition for writ of mandamus, right? Now here I'm going to have to tell you something. I'm talking to the network, right? I recommend that you really think about this twice, right? Because of the chicken wing. Well, I don't want to give you too much details on this, right? But the pipeline assigns like code names to people, right? And this is actually a technique that the network uses, right? I don't want to divest the conversation. I'll tell you about that in another opportunity. But the way they assign the names, there is a semantical meaning on some of the names of the agents, and that is a marker of prominence. Like, for example, there is a reason why the court reporter that works with Judge Telfair, her last name is something that sounds like sharer, because she's somebody whose job is to share information, right? So there's semantic meaning in the way they assign the names of the agents. So the pipeline applies something like this and also gives code names to for me, right? To, on my side, recognize the agents. So there is an agent called the chicken wing, right? The chicken wing, and I'm not going to give much details on this, but I'm sure the network will know who I'm talking about. The chicken wing is irreplaceable. And you know that, and you know why I'm saying that. And let me tell you, if the Supreme Court of Texas doesn't, do the right thing here, meaning recuse the judge Telfair and send this to an impartial judge, this is going to inevitably end with the chicken wing. And what is it going to, and let me tell you what happened. So after I learned from the informant last night that they panicked when they saw, well, they didn't panic. So, we spoke sometimes in Spanish, right? And he told me the phrase that they said when they saw the third supplement that I sent to the DOJ. They said, no jodió, in Spanish, in Venezuelan Spanish, right? That is a colloquial term that if I was to translate it in English, it would be like something like, we're screwed. Like, he got us, right? It's a more colloquial term than that, but I'm not gonna say it. So when I saw that, my immediate reaction is like, oh, so this is where it hurts, like as if I'm a doctor, right? Because it's exactly what they do, right? Once you understand what is the pressure point, what you have to do is apply maximum pressure. So what I did, I compiled the report to the DOJ and the 3 supplements that I have sent that have attached the reports to the IRS that they've been blocking, right, for the last 2 months. With explanation. Each report has a cover letter explaining the agents are reported in groups that make sense. Like, this is not like a random list of people. Each report, for example, there is a report about people that are doing industrial espionage, right? The industrial espionage cells. And that's a report that has a bunch of people that have very high liability to me, to this case specifically. And they're in that package, right? There's another that contains the attorneys that are marked in the index and that have litigated cases with the Supreme Court of Texas or with the First Court of Appeals during the 2025 year. So they are packaged in this way, right? And in each supplement, there's multiple packages of these that I sent to the IRS. So I put the three of them together, the three supplements together, and I created a book. Okay. And I want to show you what that book looks like. So if we go to actually, I think I have it here. 1 second. Right. So, this is the cover of the book. And, the title of the book is Before the United States Department of Justice, Integrity Section, Criminal Division, formal criminal complaint regarding conspiracy to deprive constitutional rights by state and federal judicial actors in the state of Texas. Submitted by Rinaldo J. Aguiar-Marcano from the 2302 Britton Ridge Drive, Katy, Texas, 77494. The only thing that is missing is to say that it's 300 feet away from the house of Robert Mueller, but it's said in the inside of the book. And inside of this book, you have what I'm describing here, right? So you have the complaint from January 8th, and this is why Pickett is going to say, according to the informant, right, or already said, that I'm fabricating this because I filed this criminal complaint on January 8th, but this doesn't mean that I haven't complained to other federal authorities before January 8th. In fact, I reported Judge Telfair to the IRS in July of 2025, something like that, right? And I haven't said a word about this in the court because this court is not prepared to deal with this issue, right? Like a family court in Texas is not equipped, doesn't have the experience, the knowledge, the technical abilities to deal with Diosdado Cabello, right? I'm not going to mix the two things, right? I'm going to resolve this issue of Diosdado Cabello in the federal court, right? I'm not going to address this but now Troy Pickett is opening that door himself, right? So this could be the end for them, I think, right? I have to run the legal vaccine, but I imagine this is the end, right? Because he's opening the door, right? I mean, I don't know. Maybe the pipeline sees a path that is better, right? I don't know. I'll see. But anyhow, if you scroll down, right? So you see, right? You have the complaint, the original complaint. And then you have the different submissions that I've been sending to the IRS. There's a transcript of a demo that I think D97 I included in that because that gives kind of context of the high-level context of the global problem that this network is, really, right? Because this is not a problem that is local to Texas or to the United States. Sorry, this is a global problem, right? But anyhow, I want to show you the third. The third supplement, right? Which is the one that when they saw it, they said, no jodió, right? That was the phrase that they used, the Venezuelans. It's on page 411 in this version. If I add something else or something, it might change, but at this point, it's supposed to be 411, right? And this book, like all this, it has all the evidence, it has the complaint that Judge Hittner suppressed from the federal court, like the one that he struck from the record. Speaking of that, the clerk, and I mentioned this in the YouTube channel, but I'm going to say it here, the clerk of the federal court of the Southern District of Texas, when in that docket entry where Judge Hittner struck the complaint, he made a mistake and he linked the wrong document. So he linked document index 13 instead of index 26. This is to create confusion, right? So if there's an investigation and the DOJ comes looking into this docket, they will click on the wrong document and they will not see the complaint that that mentions William Carl Adams, right? And the reason why they don't want the DOJ to see that complaint is because of the name Adams, which is the same last name of Chief Justice Adams, who was appointed by Greg Abbott, right? So that is the whole reason for the entire operation, right? Is to hide the connection between William Carl Adams and Chief Justice Terry Adams, who is connected to Greg Abbott. Right? That's all. So that's the reason why the clerk of the Fifth Court of Appeals made that crazy ruling. So what happened was, because, and I've described this before, right? All the procedural blocks in the Southern District of Texas. So what I did, I went to the Fifth Circuit Court of Appeals, asking for several things: a writ of mandamus, which is ongoing, it's in process, like they haven't said anything. And also, I asked for emergency stay of the state court proceedings because they have this hearing scheduled for the 22nd where they're going to try to put me in jail, right? So when I filed, they updated the docket, and the docket says, let me see if I have that docket here. I don't know if I have it here. Let me see, 1 second, because it would be good to show you, right? Let me see if I have it. No, I don't have it here. Oh, I think I have it here. 1 second. Yes, I have it here. Could it be this one? No, I don't have it here. But anyhow, I'll tell you. So, so they updated the docket, right? So I filed the motion to stay the court proceedings of the trial court, and they updated the docket saying we are not taking any action on this motion at this moment because this court does not have jurisdiction. That's what they said, right? When I see that, I think, well, maybe they didn't understand what I'm saying, right? Maybe I didn't give enough detail. So I filed a renewed motion for emergency stay, giving more details, explaining that I apply for for a reward because this is a federal court. Like they are used to dealing with issues that have to do with drug cartels and things like that, right? So I said, I applied for the narcotics rewards program in connection to information I'm providing about the Cartel de los Soles, and also I'm a whistleblower sending information, official Form 211 reports to the IRS. And these are two activities that are protected by federal law. So, it is in the federal arena, right? So I give all these details. And again, the next day, well, actually 2 days after, right, they updated the docket again saying, we don't have jurisdiction, seek relief on the lower court, on the Southern District of Texas, which is the court that has been blocking me for 9 months at this point, right? So when I see that, right, I see, well, I can't believe this, right? So I have to see this. I have to see the order. So I click on the document, right, in the entry to actually download the order. When I download the order, I see this barbarity, right? I mean, this is a crazy thing, and the craziness here is on that the person. Sorry for doing this. It's just that I have something in the way here. But the person that is signing this is not a judge; it's the clerk. So the clerk of the court unilaterally took on the role of a judge. I mean, the question about jurisdiction, this is a complex legal thing. Like this is a complex legal concept and topic. This is something that it has to be decided by a judge. Like the clerk has no say on jurisdiction. The clerk only has a say on whether the document is properly formatted or not, right? But so this is a super clerk, right? So this is a clerk that has attributions and properties like if it was a judge. The clerk makes its own rulings on jurisdiction, right? So I mean, this is a barbarity, right? So when I see this, I mean, I didn't even have to turn on the servers to respond to this. I said, I'm going to respond this to myself because usually I generate my documents using technology, right? So they are unassailable. But I mean, this is so obvious, right? That this is a crazy. I mean, this is the kind of thing that you see in Venezuela, and I've said this before. And when I see this, I cannot avoid thinking, like Diosdado is turning this into Venezuela. There's no other way to put this. Right? So now this is a clerk that has the powers of a judge, right? And in the other court, I think it was on the on the first court of appeals, they have a clerk that is able to reject documents based on metadata on the PDF file. I mean, they have, these clerks are amazing. The clerks that they have, it's super clerks, right? There's no other way to put it. So anyhow, but what the reason why they did this is because in this, and this is what I'm mentioning this in the context of the book. The reason why they did this is because in my motion to this Fifth Court of Appeals, I'm attaching as an exhibit the same second amended complaint that Judge Hittner struck from the record in the Southern District of Texas. And they don't want that to be in the docket because then the DOJ will see it, right? So they're blocking it with they cannot allow it to even get to the judge, because if they allow that, it will end up being in the docket, right? And the judge cannot strike. There's no reason for the judge to strike an exhibit to a motion. He can deny the motion, but the exhibit will stay there, right? So that's why they had to do this. But then I turned on the legal vaccine, right? And the closest say, well, the path was, well, file a motion to ask the court to compel the clerk to file the document and attach the document. That way, the clerk cannot say that. I mean, the clerk has nothing to say, right? Because this is a motion to force the clerk to file the document, right? And I accomplished what I want, which is to get the document on the record, right? So this is where we are. They haven't replied to that because this was on Friday, and Monday is a holiday here in the US. So I'm expecting, something will happen on Tuesday or Wednesday, right? But this document inevitably is going to end up in the docket, right? But even if it doesn't end up in the docket because they somehow block it, it doesn't matter. I already sent it to the DOJ and I put it in this book, because in this book, I sent it to the DOJ in the second supplement, and the second supplement is part of this book that is now in Lulu and in Amazon, right? And it's also available for free to anybody that wants to download it from the YouTube channel. The link is in there. So that's what I want to show you. On the, where would that be? That would be on the second supplement, right? On the third supplement, let me see. Yeah, it's on the second. And the second supplement is on page, let me see. Just a second. The second supplement. It's on page 143 on this version, right? If they keep going and they make me add the chicken wing, the page number is going to change. And there's a certificate of service here that says that I sent this to Pickett and to William Carl Adams. Both of them, I sent them the 3 supplements, right? So they've been served with this. So in this, here you can see, no, this is not it. This is the second supplement, okay. So in the second supplement, as an exhibit, I think is exhibit F. This one that says realtor's emergency motion directed to the court to compel the clerk to file and for expedited judicial review. Right? So I'm asking the appellate court of the Fifth Circuit to force the clerk to file the document, because that's their job. It's a ministerial duty. They cannot rule on jurisdiction, right? And in this particular filing that we're going to see here, it would be F, right? So let me see if I can find it. Yes. Yes. So this particular, right. So it has the document that the clerk refused to file, right? I'm asking the court to force the clerk to file it. So I'm attaching the document that she didn't file, right? I'm saying she, or could be a date. Right? I don't know. In fact, I received 2 of these letters in which the clerk made this ruling, right, of their own substantive their own ruling on substantive matters, right? And it was 2 different people. And they're mentioned by name in the complaint to the DOJ. I'll read you the names in a second. But let me show you this first, right? So this describes the emergency, right? That on January 22nd, I have that hearing with Judge Telfair, and although I have a 3rd verified motion to recuse that he cannot rule on, unless it's to recuse himself, they may try to put me in jail for contempt, quote unquote, on an order that is void because they entered it without jurisdiction, and that is obvious, right? It's a fraudulent document. I say here why the Southern District of Texas is not an adequate forum, because they've been blocking me for 9 months, right? How can I expect them to take prompt and adequate action on this in 3 days when they've been blocking me for 9 months? It's unreasonable, right, to expect that to happen. Okay. And you can see that this was served to G. Troy Pickett and William Kyle Adams, who is the principal of the Adams Law Firm, which is the firm that filed that fraudulent document on October 10th that tricked the first appellate court into dismissing my petition for writ of mandamus by a panel led by Chief Justice Adams. I note the 2 Adams in the same case. Right? In the same sequence, not only the case, the same sequence, right? But importantly, in this filing that I'm asking the 5th Circuit Court of Appeals to compel its own clerk to file, on the Exhibit B is the 2nd amended complaint that Judge Hibner struck from the record, and then that clerk mislinked in the document, right? So it's here. And that's what I want to show you. And you will see that William Kyle Adams is the main respondent in that action, right? And G. Troy Pickett is the second one, right? So this is what they want to hide. This is why they take all these desperate actions, so this doesn't land in the docket. But it's futile because I am aware of what you're doing, and I'm going to go to any links to get this to the DOJ, right? I already sent it to them via FedEx, registered mail. I sent it through other channels outside that you cannot see, right? Because I can also transmit information when I go out, right? So you don't know where this is coming from, right? But it is already on its way to the DOJ. And on top of that, it's on multiple books in multiple printing services, right? It's public record. You can't hide it. So anyhow, that's the saga with the 5th Court of Appeals now. So, but you see now, this is at the federal appellate level, right? I'm telling you, this is gonna end up in the desk of the chicken wing. I mean, the entire book. And if the chicken wing sees this, what is he going to say, right? And the chicken wing is irreplaceable. You know that. So sometimes one needs to, how do I say this? Sometimes it is better to cut off on your losses, right? There's no need to lose everything. I don't know if that makes sense, but I understand, right? This network, because they're accustomed to winning 98% of the elections worldwide, right? And they're not used to losing, right? So they can't retreat, right? They don't know how to retreat, and I think that's a mistake in this case. But anyhow, in the 3rd supplement, there is a mention of Rafael Ramirez, who was the ambassador to the UN of Diosdado Cabello, right? And also the people that own residences surrounding 2 US presidents that are marked in the index of Diosdado Cabello, who is an individual wanted by the DOJ on narco-terrorism, right? So that's why when they saw the 3rd supplement, they said that phrase, no jodió, right? So I don't know. It's let's see what they do, right? But so this book that has almost 600 pages of hard evidence, like, so this is not transcripts, and these are court documents that they themselves created and signed, right, in multiple courts. And I'm talking about G. Troy Pickett, George Telfair, William Carl Adams, the Honorable Susan Brown, Chief Justice Adam, like all of them, right? Like all these documents have their signatures, right? So I don't know. Sometimes it's better to let it go, and I invite you to think about it, right? Okay, so I think with that, it's a good point to stop this demo. But I'll leave you here also this is the cover of the book, and I'm gonna give you the ISBN number. Oh, and by the way, this book is also registered with the Library of Congress, and of course, I'm sending today a copy to the Library of Congress, right? Which is a law library, right? So imagine, I understand that the careers of these judiciary actors is over, right? And that's hard to accept, but the network is bigger than them, right? You may, take those losses and walk away. There's still time. So the ISBN number is 978-1-97-148-117-3. And this is a paperback, okay? And the Library of Congress number is 202. Sorry, let me increase the font a little bit. It's hard to read. 202-59-24-729. Okay. So with that, I'm going to end this demo. Thank you so much for your time, and I'll see you on the next one. Bye. Let me do this.